you.
Judgment in the appeals, Littlewoods Limited and others, and Commissioners for Her Majesty's Revenue and Customs.
Lord Reid will also explain this decision of the Court.
In 1998, the House of Lords held that a person who paid money under a mistaken understanding of the law was entitled to recover it. Under the law then in force, the time limit for bringing a claim to recover the money did not expire until 6 years after the mistake was discovered, no matter how long ago the mistake had occurred. This was liable to result in difficulties for recipients of the money who had long since spent it. Her Majesty's Revenue and Customs, for example, might receive a claim for the repayment of taxes which had been paid under a mistake, but the money might have been spent by the government long ago on the health service or state pensions or other public services. Legislation was introduced following the House of Lords decision in order to protect public finances by retrospectively imposing a time limit for bringing claims, but that legislation was held to be in breach of EU law. The revenue's problems were exacerbated by another decision of the House of Lords in 2007, which held that under the common law, the amount to be repaid should include compound interest over the period since the date of the original mistaken payment. Over a long period, compound interest can accumulate into a very large amount. This forms the background to the present case. Littlewoods overpaid VAT to the revenue between 1973 and 2004 as a result of a mistake. After the mistake was discovered, they made a claim for repayment of the VAT plus interest. The revenue repaid the VAT, a total of £205 million. The revenue also paid simple interest, amounting to £268 million. In these proceedings, Littlewoods seek the difference between the simple interest that they have received and the compound interest to which they say they are entitled following the House of Lords decision mentioned earlier. That additional interest amounts to £1.25 billion. This is a test case. The total amount of compound interest claimed in VAT cases alone is estimated by the revenue at £17 billion. Two issues arise in the case. The first is whether, as a matter of English law, Littlewood's common law claim for compound interest is excluded by provisions of the Value Added Tax 1994, which provide for the payment of simple interest. The second issue is whether, if Littlewood's claim for compound interest is excluded by the 1994 Act, that exclusion is contrary to EU law. The lower courts held that Littlewood's claim was excluded by the 1994 Act as a matter of English law, but that denying compound interest was contrary to EU law, which took priority over the 1994 Act. As a result, Littlewood's claim succeeded. Both parties now appeal to the Supreme Court. Other issues are also raised in the case, but they would only need to be decided if Littlewoods were to be successful on one or other of the two issues which I've mentioned. The Supreme Court unanimously dismisses Littlewood's appeal on the question whether the 1994 Act excludes their claim as a matter of English law, and the Court unanimously allows the Revenue's appeal on the question whether the exclusion of compound interest is compatible with EU law. The result is that Littlewood's claim is rejected. On the first issue, the relevant provision of the 1994 Act states that the liability to pay interest on overpaid VAT under that section applies if and to the extent that the revenue would not be liable to do so apart from this section. On a literal reading, that would permit a common law claim for compound interest to be made outside the Act. However, the scheme created by the Act is inconsistent with the availability of a concurrent common law claim to interest. The right to interest under the section is subject to several limitations which would be defeated and rendered pointless if it were possible for the taxpayer to bring a common law claim. It cannot therefore have been Parliament's intention that a common law claim to interest would be permitted where VAT was repaid, as that would fatally compromise the statutory scheme and render the section a dead letter. At the time when the section was enacted, common law claims of the kind made in this case had not yet been recognised by the courts. What Parliament must have had in mind were various statutory rights to interest that then existed. In those circumstances, this court holds that the section must be construed as referring only to statutory liabilities to pay interest and not to a common law liability. On the second issue, the High Court referred to the European Court of Justice the question whether the exclusion of a right to compound interest was compatible with EU law. The High Court and the Court of Appeal construed the court's judgment as meaning that the exclusion was incompatible with EU law. This court disagrees. When read as a whole, the judgment makes it clear that there is a general entitlement to interest on tax levied in EU law, in breach of EU law, which would include VAT paid under a mistake, but that it's for member states to determine whether the interest rate is simple or compound, subject to a principle of effectiveness. That principle requires that the interest should amount to what the court described as an adequate indemnity for the taxpayer's loss. The lower courts construed the phrase adequate indemnity as meaning complete reimbursement of all loss, and therefore as requiring the payment of compound interest. But the phrase, and its equivalent in the other language versions of the judgment, can also bear the wider meaning of reasonable redress, and that is how this court considers that it should be understood. 3 reasons support that view. First, the European Court indicated in its judgment that the simple interest already paid to Littlewoods would be an adequate indemnity. Secondly, there is a widespread practice among member states of awarding taxpayers simple interest on the recovery of taxes which have been overpaid. And if the European Court intended to outlaw that practice, one would have expected it to say so in clear terms. Thirdly, the prior and subsequent case law of the European Court is consistent with the principle that there is an EU right to interest, but that the rate and method of calculation of interest are matters for the member states. In summary, the European Court requires member states to provide reasonable redress in the form of interest in addition to the principal sum, but allows them a discretion as to how the interest is calculated. In this case, the payment of simple interest, considerably exceeding the principal amount, cannot be regarded as having deprived Littlewoods of an adequate indemnity.